there has been a tussle or a face-off between several chief ministers and governors, and perhaps Supreme Court statements and the verdict that has come out is also important in that context, because as Arvind Gunasekar is mentioning, the Supreme Court has looked at balancing between the two with strong responses, whether it be for the governor as well as the chief minister. But if you look at what's been happening in West Bengal or in Telangana, in Tamil Nadu, in Kerala, there have been an increasing war of words between the governor and the chief minister. So Arvind Gunasekar, if I can get you now into this picture, and if you can give us the top 3 takeaways of what the Supreme Court has said. And you were talking about how the messaging for the governor has also been very important. The Supreme Court has said, you're not a political office. This at a time when there have been several political overturns between the chief ministers and governors of several states. Though this is particularly to Punjab-related order, can we see this even beyond in terms of the political discourse currently in the country? Arvind, what are your top takeaways?
Sneha, it's very clear that we are witnessing kind of a disagreement, or in a way an ugly public battle or outburst between the elected government in the opposition ruled state with the Raj Bhavan. It's not just in Punjab, like you mentioned. We have seen similar kind of disagreements, or in a way a kind of an ugly outburst in states like Tamil Nadu, also in states like Kerala, in states like West Bengal, even to an extent in Jharkhand, etc. And all, we have seen how the elected governments have been in war of words with the governor's office. And again, what we have seen in Punjab this time is unprecedented, Sneha. We have been reporting a kind of governors taking a strong call or refusing to act on the aid and advice of the state governments. We have seen several such cases, and the cases at the end of the day have reached Supreme Court. But what we have seen in Punjab this time is unprecedented, because there have been decisions like, let's take the case of Maharashtra, because in the case of Maharashtra, the earlier government, MVA government, the Mahavikas Aghadi government, if I remember correct, they had recommended certain names for appointment or nomination to the MLC, the upper house in the state, and also they also recommended for an speaker's assembly election. Even in that particular case, the Maharashtra governor sat on those files. He didn't act on those files. Similarly, even in state of Tamil Nadu, when the state government cleared several laws, when the laws were legislations were passed in the state assembly, the governor's office, the governor was sitting on those files. He didn't give an assent. So that to that extent we have seen. But what we witnessed in Punjab was unprecedented, because summoning an assembly has to be on the act and has to be on the aid and advice of the Council of Ministers, because that has been the practice. Because the Constitution, if you could see, Article 163 clearly says that there has to be a Council of Ministers who will aid and advise the governor. That's Article 163 of the Constitution. That makes it very clear. Read Article 174. Article 174 gives power to the governor to summon, to dissolve, or to prorogue any assembly. So Article 174 gives the power to the governor to summon or dissolve an assembly, and Article 163 says that the governor has to act on the aid and advice of the Council of Ministers. So reading both in consonance, it's clear that governor can invoke Article 174 to summon the assembly. Under Article 163, that is on the aid and advice of the Council of Ministers. That's as simple as clear, and that has been the practice all this while. But for the first time, we witnessed a governor refusing to summon an assembly despite the Cabinet Council of Ministers recommending to do so. That seems to be the case that has reached Supreme Court, and that's where Abhishek Manu Singhvi said that this is a clear open and shut case. The governor should have acted on the aid and advice of the Council of Ministers. In this particular case, despite even though the letters have been, even if we go by the argument of the Solicitor General appearing for the Raj Bhavan, that the letters were not in good taste, can that be the ground that the governor can defy Article 163 and also Article 174? That seems to be the point that Abhishek Manu Singhvi, appearing for the Punjab governor, brought to the notice of the Supreme Court, and Supreme Court, taking note of the same, made it very clear that the governor has to act on the aid and advice of the council.